I think that we can start now. We will have recording from this meeting. I hope that you don't mind. If you have some issues with that, so please turn off your cameras. Yeah, so I am very honored to welcome today Valentina and Magdalena. Thank you for accepting the invitation to the workshop on systemic consequences on abortion decision of the Polish Constitutional Tribunal and American Supreme Court. Unfortunately, we will not have as a speaker Mari today, but we will say some words also about this decision of the American Supreme Court. Moderator for today's meeting is Valentina Rita Scotti. Thank you, Valentina, for accepting the invitation again. Valentina is an associate professor in comparative public law at the European Law and Governance School of the European Public Law Organization. Valentina is also co-chair of the Gender and Constitutions Research Group within International Association of Constitutional Law. I am very grateful for the sponsorship of the research group. Thank you, Valentina, for providing us with this sponsorship. And I am also proud to announce that the research group on gender and constitution in Poland has been recently accepted by the faculty council. And today we have the inauguration of our scientific or research activities. So I think that Valentina, this is now time for you. So please take the floor.
Thank you very much for giving me the floor, Agnieszka. It's a real privilege to be here today, not only because it's an opportunity to meet friends that are very dear to my heart, estimated colleagues with which we had very fruitful cooperations in the past, but also because it's a privilege to welcome the Gender and Constitution Research Group in Poland among our partners of the, let's say, the main house, the Gender and Constitution Group of the ICL. So I'm very glad that you succeeded in this, and for me it's an honor to be the first moderator of your activities. I'm sure that we will do great things together also in the future. And it is also a privilege to be here for discussing such an interesting topic, because I believe that when we do research with regard to gender, having a light always on women's reproductive rights is a very important thing. We, for a very long time, considered some rights as a given, something that no one could have taken from us. And we have seen the protection of reproductive rights increasing during the last century, but unfortunately we are now in a completely different scenario in which reproductive rights are constantly jeopardized, and what is more relevant and more tricky for us to take into consideration is that normally the challenges to these rights have come from parliaments. It has been often through laws that women's reproductive rights, but I would say reproductive rights in general, have been jeopardized. Now what we are observing is that courts are entering in this very complex field in order to take decisions on behalf of the legislator. And this seems to me a relevant aspect that in our researches we must take into consideration. Normally, we have seen Constitutional Court and Supreme Court take a certain distance from ethical issues, and abortion can be included among ethical issues. Of course, we have also seen that Constitutional and Supreme Courts intervened in order to extend the protection of women's rights based on equality, based on the right to privacy, based on the anti-discrimination principle. But now we have observed a U-turn. Constitutional and Supreme Courts are reducing the protection of reproductive rights, basing this decision on completely different grounds. Magdalena will speak about the situation in Poland, so I will not say anything about this. She's an expert and she will talk about it better than I can. But if we, for instance, take into consideration the US case, unfortunately, we cannot have Mary with us, so I would say some word in this regard. Here, the real issue that was under discussion was not exactly the right to abortion. Here it was a question of federal competencies. The whole game was played against women, but without taking the burden of putting at the center the relevance of this right. It was everything grounded on whether this field should be legislated by the federal constitution at the federal level or by the state level. And this gives us also the measure of how relevant women's rights and the principle of equality, I would say, in a broader view, is becoming less and less relevant in our world. So I'm really grateful to Agnieszka for putting together this workshop and for giving us the opportunity to think about what is happening, because the approach of courts in the matter of rights is becoming the real field in which we will have to battle in order to protect the principle of equality, women's rights, gender rights. And it's important that as the Gender and Constitution group, we continue to organize this kind of events. So once again, this was a long introduction just to say once again that I'm very proud and honored to have been invited here today. And without further ado, I already took too much time for being just a moderator. I will leave the floor to Magdalena Grzib, I hope the pronunciation is correct, which is assistant professor at the criminology department of the Jagiellonian University's Faculty of Law and Administration in Krakow. Sorry for all the mispronunciation in your presentation, but Magdalena, the floor is yours.
Thank you very much, Valentina and Agnieszka. Thank you for the invitation. Well, I can see that a lot of us are from Poland, so please feel free later on to complete or comment my presentation. I just would like to comment the systemic consequences of the ruling from 2020 Constitutional Court number K120. Well, so the ruling that was made in October of 2020 actually is not a new or groundbreaking argument, but rather a continuation or elaboration of the ruling K2696 on abortion from 1997. So, like, logically, I must refer to that historical ruling. And first of all, in a nutshell, one of the problems discussed then, 2 years ago, it was that in that ruling, there were incorrectly appointed judges. There were so-called doublers, the judges that actually replaced legally elected judges in the Constitutional Court. And additionally, 2 of the jury were former MPs of the ruling party in the prior term of the office of our House of Parliament, Sejm. And what is more, even more, one of that former MP, Krystyna Pawłowicz, had signed as an MP the same application or constitutional compliant to the Constitutional Court regarding abortion law in that prior term from 2050 till 2019, which actually was raised concerns about her impartiality. But leaving aside the problems of the composition of the jury, in that case, I would say the main systemic issue was that whether the Constitutional Court was allowed to rule on the scope of admissibility of abortion. It is deemed, and so were the intentions of founding fathers of our 1997 Constitution, to leave such decision to democratically elected parliament. I mean here the discussion regarding the formulation of the protection of the right to life in the new constitution. However, that concern was raised already in 1997 ruling in the dissent opinions to the ruling of the former Constitutional Court. In 1997, we witnessed the Constitutional Court overturning the liberalization of abortion law from 1996, which was adopted by a left-wing parliament majority then, and dismissing the rationale for the permissibility of abortion on the ground of the personal and material predicament of the pregnant woman. It was called then social ground for abortion. In such context and historical and political background, the ruling from 2020 was a kind of follow-up of that approach, actually. The Constitutional Court again steps into the role of parliament in the lawmaking process in such contentious question as reproductive rights of women. One has to say that 1993 abortion law that outlaw abortion on the social ground, which was legal in Poland since 1956, was adopted in fact against public opinion by then by the right-wing democratic government on the demand of the Catholic Church. The democratic transformation in 1989 in Poland and the introduction of the rule of law from the axiological or ideological point of view was actually a conservative and Catholic shift in public sphere, and particularly in the realm of women's rights. Going into details, one of the main consequences of the 2020 ruling was the broadening of the scope of application, again, the broadening of the scope of criminalization of abortion in our penal code. I refer here to the Article 152, paragraph 1 of our penal code from 1997. The article, the provision covers the situation of performing abortion against the provision of the abortion law. And since the publication of the judgment in January 21, which is 3 months after the ruling, performing abortion because of the fetal abnormalities became illegal, and the medical staff was running the risk of criminal prosecution in case of continuing performing such abortions. Just to give you a picture, up to then around 98% of all legal abortions in Poland were performed on that ground, which was more or less 1,000 abortions per year in last years. Which is to say that that ruling, in fact, banned almost all legal abortions in Poland. To clarify, the Polish so-called abortion compromise from 1993 did not envisage prosecuting of women themselves in performing abortions, but all the actors who were involved in helping or assisting her, which is the doctors, the medical staff, the partners, friends, all people providing help or abortion services in any way. In fact, that was the compromise, not criminalizing the women. Since the Catholic Church by that time and their political partisans were aiming criminalization of women too. So that was actually the real compromise. Okay, so maybe later on I will answer the question. Broadening the scope of the criminalization raised another concerns from legal scholars, since only within the legislative process it is allowed to state new criminal offenses, and the Constitutional Court obviously is not allowed to create new criminal offenses, which actually happened. However, no matter the dogmatic or theoretical concerns and critics of the ruling about the validity of the ruling is binding for almost 2 years from then and has profound consequences on our public health system regarding reproductive rights and decisions made by doctors regarding pregnant women in case of detection of fetal malformations or abnormalities. Doctors, in fear of criminal liability, do not perform therapeutical abortions, even to save women's lives. How it happened in high-profile case of 30-year-old woman called Izabela from Pszczyna, a small town in South Poland, in September 21. So we do not know the real number of such cases. One can tell that before that ruling, we did not hear about such cases, that women were dying because the doctors were denying her abortion even to save her life, though she was actually in a situation of having a really serious fetal abnormalities, and she was actually entitled to have abortion on the ground that was banned by Constitutional Court, the fetal abnormalities. One of the systemic consequences of the ruling is also the increase of abortions performed on the ground of saving women's life or health. We have by far only numbers from 2021 year, and we saw that there was a serious increase in such abortions. Before the 2020 ruling, there were only few cases per year. There was a visible hostility within the medical staff to apply that premise. So we can observe now in a way a shift and recurring to that premise instead of fetal abnormalities ground. The justification is that the risk of carrying a pregnancy and being forced to give birth to a child severely ill or deformed is a risk for mental and physical health of pregnant women. However, that increase does not satisfy the women's needs and does not ease the doctor's fear and reluctance to perform procedures that was visible, and that was a serious systemic problem in our health system before 2020 ruling. And it has serious ramifications for women's constitutional rights, her life to life, health, and right to medical help, which is also guaranteed by our constitution. And actually, the last thing, the ruling from 2020, and meaning actually forcing women to give birth of severely ill or suffering children, which is a case of forced childbearing, went further in our restrictions to abortions, and we can see the analogy from the 1997 ruling. I would say the ruling from 1997 was ruling that actually forced women to give birth to unwanted children, and now in 2020 the Constitutional Court forced women to give birth to severely ill or handicapped or disabled children. Some of the children with even lethal illness that were actually condemned to death for within a couple of months or weeks after the birth. In such a situation, where women are actually forced to give birth to severely ill children and take care of them, obviously, the state does not provide sufficient help in the care of that children. The main burden of such public policies is placed in the private sphere on parents' shoulders, and particularly mothers. And that leads to systemic exclusion of women, mothers of disabled children, from labor market, and in general from public sphere, from their full participation as citizens and enjoyment in their basic civic rights. Maybe here I will stop by far.
Okay, thank you very much, Magdalena, for, such an interesting but also very sad relation about what is happening in Poland. I have some questions for you, but I would like to leave the floor to our participants first. So, of course, as Magdalena said, feel free to raise your questions also in Poland. Maybe she will then be so kind to translate them for me as well. But just to break the ice, if you want to raise them in your native language, it's absolutely not an issue for me. So if you want to raise your hands, I will give you the floor.
Well, I can see a question from Mrs. Katarzyna Widła-Sklimek. Now the criminalized is only performing abortion, is not undergoing abortion, is not criminalized by far in Poland. Though we can hear the voices that it should be criminalized too. There were some drafts that were aimed at criminalizing also women who undergo abortion.
Which is another very relevant aspect of restricting the discipline. I don't know whether it's me or I cannot see if questions are coming from the chat. So Magdalena, if you see them, feel free to tell. Okay. And if meanwhile we don't have questions, there is something I would like to ask about the connection with the supranational level. So I'm wondering, after some
well, so we have some issues with Valentina's connections. Oh, yeah.
I'm so sorry. You lost me at a certain point. So I was raising a question. Can you hear me now?
Yes.
So my question is about the relationship between the National Constitutional Court and the supranational level. After the decision, do we have any application lodged at the European Court of Human Rights for infringement of, I would say, right to life? Because from what you told us, it's both the right to life of the mother and even on the unborn that is obliged to come to this world that can be violated. So is there anything like this going on, or?
Yes, they were filed several complaints by women to European Court of Human Rights, but as far as I know, by far there were no decisions.
Okay.
But
So
several women did file complaints.
Okay, let's
However,
hope in the activity
we have
of
another political discussion in Poland about the binding force of the decision of European Court of Human Rights in Poland. So even if European Court of Human Rights would rule that decision goes too far in restricting women's rights, like right to life, dignity, whatsoever, I seriously doubt if current government would change law in any way. Maybe it would be forced to pay some indemnification, but that's all. They don't care about European Court of Human Rights rulings, actually.
As an expert about the Turkish legal system, I'm quite familiar about this situation that you are highlighting. So I understand. I understand what you are saying, and I thank you very much for the answer. Do we have any other question?
I would like to say that anybody can turn on the microphone and speak if you wish to ask a question, or maybe
make a comment.
Comments, yes, for us, because I see that there are some people that are interested in this situation a lot. So please ask or comment on what we are discussing now.
Let's say, don't be shy. The workshop is meant to discuss together. So feel free to be with us, to raise your voice and let us know about your opinion and comments.
So maybe I will comment, and also I have some questions for discussion, for general discussion, because obviously it is like difficult situation. I would like to ask Magdalena and Valentina also for your opinion on to what extent the worldview of judges affects the decision in any jurisdiction, like on women's rights. It might be obviously the abortion, which is our topic, but it might be also connected with other rights of women. Because I think that it was like in American and also in Polish case, it was a very important factor for this decision. One is obviously formal, which is in Poland it is important because formal issues indicate that it might be some some question of validity of this decision, but it is different issue. But for me, I see the problem with exactly the worldview of judges that are more conservative than not conservative, just simply putting them in one group. So what is your opinion about this? Whether the worldview affects the decision making in courts or not?
Please, Magdalena, you go first.
Okay, so that I do think it has fundamental fundamental meaning and influence. We saw it in the 1997 ruling, since the Constitutional Court president, Professor Andrzej Zoll, had openly really pro-life beliefs, and he was really a deep faith practicing Catholic. And I would say, just looking at that case from that legal realism perspective, that his personal views on abortion shaped the decision of Constitutional Court in 1997, and with his great authority, he could impose on other judges or convince them to his views on abortion. I would say so. And the other interesting thing I saw in 2022 ruling in the US Supreme Court is that the media comments and all experts, actually, they focused only on the views and political background of the US Supreme Court judges. I did not see any critical analysis of the judgment, of the motivations. It was like, actually, I would say not important. It seemed no important. They were only discussing the Supreme Court composition, the number of the justices nominated by the Republican Party and the Democrats, and actually the Republican Party, actually they nominated all the judges only within the this focus on their views on abortion. So that was their main I would say criteria for election or appointing judges, and the discussion on the merits, on the motivation, the argument of the decision was actually non-existent in the reaction, in the debate about that ruling of Supreme Court in Dobbs versus Jackson ruling. And maybe it's I would say the sign of the times in general, but the merits and the arguments are really, I would say, not the most important or the utmost important thing within the discussion. It was just political decision. They motivated in a way, no matter what, we don't care about it, because we have that power to impose our views and beliefs on the whole society, and we're doing so, even if most of people say that the argument is really weak and it doesn't make any sense. And so also in Polish debate about the ruling 2020, we could observe, maybe not in such a way as now in the US, but we could also observe that that point of view, that actually the judges were really biased by their personal views, and actually they just expressed their views on the constitution or abortion laws, even against the fair interpretation of constitution or the intentions of founding fathers of constitution.
I could not agree more with Magdalena. I totally believe that these are fields in which the personal opinion matters a lot, and in several cases people are appointed to the court mostly looking at their opinion on ethical issues more than others. And probably what is interesting is also to look, if we want to have a comparative overview, to look at the way courts are appointed and the way in which they decide. Because if we look, for instance, at the Italian Constitutional Court, the appointment procedure is allows for knowing less about these issues, so judges are less exposed to a certain debate, and also in the end we have the opinion of the court, so it's difficult to understand which position each judge took. But in cases like in the US, it's evident that they should be strongly opinionated on ethical issues, because they know that they will be then exposed to the media. And as Magdalena said, this is what happened in the US. we have read also among scholars very few comments that were totally focused on the content of the decision. Probably none of us was able to escape from the trick of discussing about the personal opinion of the judges. So, and we knew when they were appointed by Trump that this was in the air, unfortunately. So we have two questions from the chat. The first one is from Katarzyna. Katarzyna, you know that I'm unable to pronounce correctly your surname, but I will say Sekowska-Kozlowska. She's asking, what do you think, Magdalena, about performing abortion because of bad mental health of women? And if you agree, I will read for you also the other question from Darius. How do we need to change the Polish constitution to implement a full right for abortion? Maybe we don't have to change it. It's just a case of another interpretation by Constitutional Court in a different composition, because I guess deleting right to life from Constitution wouldn't be a reasonable option. Both of them are interesting questions. So please, Magdalena.
In general, I am for including also mental health and admissibility on abortion on that ground, though I'm not too radical in that questions. It's really complex question. It's just, as far as I know now in France, there is a constitutional debate on introduction right to abortion into constitution or not. And also there are discussions of the date of using that mental health ground to allow abortion, but I would say that nowadays in our current situation, that that the protection of mental health of women is the only admissible way to get legal abortion for women. So. And I would strongly recommend to use that ground, because we don't have anything else by far. However, I don't see these were actually the concerns that were raised by my French friends, but I'm not aware exactly how the French discussion is going. I don't see that women, even if 9th month of the pregnancy, can use that ground to demand abortion on 9th month the pregnancy. However, I would say that till the 24 or 22 week, I think it's absolutely reasonable to use that ground or premise. Regarding the question of right to life, well, the interesting thing about the 1997 ruling is that the ruling was made under the former constitution, which was the constitution which was like our 1952 constitution, and let's say little constitution, right? And in that constitution, we had no right to life. So this is really interesting, because the ruling made under the former constitutions remain binding under the new constitution. And in a situation when we had no right to life protected in the constitution, it doesn't mean that our right to life is not protected at all. By far, and by the Constitutional Court, it was concluded from rule of law by that time. I think it's important, basic human rights, and we can have it included in our constitution. I just wonder if it's really a realistic option to change that formulation, which is actually broad and just leaves decision to the parliament. if it's really realistic option to think about changing formulation of that provision to include right to abortion. I really doubt it if we can change it.
Thank you very much for your answers, Magdalena. Do we have any other questions or comments?
I think that somebody also raised hand, but I don't see it now. So maybe this is the right moment for speaking. Like if anybody wants to yes to say something, so please turn on your microphone and just speak. No, okay, so maybe I will start because I have many questions or comments also. Yes, also the issue is that the effect of the judgments in both jurisdictions is the violation of women's rights, but we have different like ways of that. What did apex courts in our state? So in the United States, the Supreme Court left the decision to the state parliaments, which is what we in Poland would like to see, because our constitutional tribunal said that even, okay, so because it provided the interpretation of the constitution in such a way that Polish parliament or even referendum is not possible or really restricted, because constitutional tribunal put the protection of the unborn child directly to the constitution in the meaning of the right to life or protection of life. So we see that we have two different directions of the decisions, but the same effect. And yes, my question is how to overturn this situation. Do you see, Magdalena, and maybe Valentina also, I would like to hear your opinion, how to escape from this unfortunate situation for women. Yes.
Please, Magdalena.
Well, by far, I'm quite pessimistic and realistic, and at one time, and I just think that if our government would change, maybe they would pass laws liberalizing abortion. But on the other hand, it may happen that every changing government and every term they will pass abortion, and then they will retract abortion for women's life, and it would be on and on the same way. But for now, it seems for me only a political decision. I was thinking about referendum, but when it comes to referendum, it's like with the public with polls, opinion polls. Everything depends of how we ask the question, and if our law and justice government would organize abortion, I have no doubt that they would ask questions in a way that would make people be against any abortion. So we have to be very cautious about referendum, because I guess it would be a very similar case like with the referendums on death penalty. Maybe we shall accept that premise that there are some cases that do not require referendum. I don't know. On one hand, yes, in Ireland, the referendum succeeded. I would like to believe that in Poland too. However, as I said, everything actually depends of how the questions would be asked. So it's actually susceptible to kind of manipulations from the politicians.
If I may add, and this connects me also to Carolina's question, I believe that in this particular field, when ethic issues are relevant, probably it's a matter of societal belief. I mean, before that, reaching the level of a referendum or a bill proposal in the parliament, I believe that we need to analyze the society to which we are talking. And unfortunately, we are observing that European societies are becoming more and more conservative. So people are increasingly willing to change the approach to women's rights in general. And what we are discovering is that a part of this conservative movement is composed by women. We are observing a remount of what is called familial feminism, in which the interest is increasingly for protecting family, supporting maternity, which I don't want to be misunderstood, are all very valid points, but if on one side we have those who decide to be a family with children and all the rest, on the other side there is the freedom of choice of women. I believe that what we are discussing here is the freedom of choice. And unfortunately, we are observing societies that increasingly believe that this is not a matter that can be left to a choice. Also in the case of Ireland, I believe that the referendum succeeded because it was so evident that the society was changed that they had to put the issue on a referendum. Otherwise, my opinion is that governments will always try to avoid to discuss this via referenda or in a legislative process, because they know that this is the way for losing a vote, discussing ethical issues in general. So I will stop here. Maybe Magdalena, you would like to add something with regard to Carolina's question, and then we can give the floor to Eva, who raised the hand.
Yeah. Well, one important change that we observe since, I would say, 50 or 20 years, that when in the 90s, our abortion ban was ruled, and then the law was liberalized, and then the Constitutional Court ruling from 1997 outlawed it again. In general, most abortions were performed by the doctors in, let's say, clandestine situations. Like, I would say that first year after the ban, it did not change a lot for women, because even in 80s, many women performed abortions during the private visits on the doctors. And actually, for almost 30 years, we did not have a real, let's say, prosecution or applications of that law regarding doctors. There were some prosecuted doctors, but they were like, you know, singular cases actually. But now from the years 2000, and also because of the development of the internet, many women, they can buy abortion pills online. Also, we can observe that the sector of that kind of, we call it abortion tourism, to Germany, to Slovakia, to Czech Republic developed too. So women in Poland developed many ways to get their way to get abortion when they need it. The only actually condition was to have money. But these were different situations than we can have now, since the abortion of the banning abortion on fetal abnormalities ground is all fetal abnormalities in general. They appear often in the second or third semester of the pregnancy, when in general taking the pills pharmacological abortion is not possible anymore. Or even going to Netherlands, it could be really difficult. And again, you always need money, have your own private resources. So actually, it is discussed that what we observed in Poland after the communism collapse and the abortion ban was introduced, or so-called compromise, was the privatization of the abortion services and reproductive rights of women in Poland. Women could perform abortions if they could afford, and only women who could not afford to perform abortions were set aside. No one cared about them. But in general, the system do not care a lot about poor people, especially system organized in a neoliberal way, as it is organized in Poland. And what is more, most poor women, it is deemed were conservative views. So they, on let's say declaration side, I would say that they were more against abortion than women from middle class, for example, or big cities. So I can see a lot of paradoxes here that I don't know how to resolve it, because most of those women who were entitled to legal abortion on malformalities or of fetus in the pregnancy, probably they were women that could not afford abortion, or actually they were maybe women with conservative views. Since Poland, now we can observe a very rapid or even violent change within our attitudes toward Catholic Church. But for more than 20 years, most of our society was actually really was really, I would say, religious one. Even and I would say that abortion ban did change our society in a way that in, I would say, 2015 or 20, many women, they believe or they agreed on or abortion compromise. They did not accept it, let's say, abortion on the social ground. They believed that if woman get pregnant, she should bear a child always. So this is kind of paradoxical, because abortion ban affects mainly poor women, but on the same time, poor women in general had conservative view, or maybe I would say more conservative view, maybe. So it's for me really complex question. I do not have full knowledge about social support for abortion right now. I would say that young women, even poor women, are for abortion. The moral authority of Catholic Church declined severely in last few years. But on the other hand, we have very few young women because of the demographic decrease. So I'm not sure if they can shift political polls during elections. So it is really complex question. Or if they views on abortion is the main political question for them, that form their political decisions. That's the other thing.
Thank you very much for this answer, Magdalena. That gives us, I would say, a lot of food for thoughts in this regard. So, Eva, would you like to take the floor and ask your question or make your comment?
Yes, a question. I have a question about the decision making about the abortion. The girls who are under 18, and I'm talking about the girls who are 15, 16, 17, not younger, of course. Who should make that kind of decision? The girl? The parents should have influence over that, or maybe some kind of commissions? How to regulate that problem?
Magdalena, would you like to say something on this regard?
Well, first of all, I would always look at the cases of other countries, how it's regulated in other countries. I would say that young women, even or 15 or 17, would have right to take her decisions. However, like I have no clear stance on that actually.
As far as I remember, the main clue that has been used right now is the legal capacity. Once you have full legal capacity, you may take this decision. So the two things goes together. And even if, okay, you are almost in the age of your legal capacity, before of that moment, it is still the legal tutor. So whether the parents or the person who is entitled to take all the other decisions, which I understand have a position, is relevant. Women who are already sexually active should be able to take this decision, but still legally, it's the legal capacity that gives us the red line for taking this decision. And personally, I also agree that the state should put a reasonable red line for taking this kind of decision. Probably with regard to these young generations, it opens another very relevant topic, which is the topic of the sexual education, what our countries also lack. And when we talk about restricting abortion, we observe that also the investments in education are restricted. We need to make younger generations aware of what is sexual freedom from all the perspectives. Of course, we are not saying that abortion can be the solution to a problem. It entails a broader perspective on what does it mean to be sexually free. However, this is maybe just my opinion, and sorry for expressing it out loud. Do we have any other question or comment? Agnieszka, you want to say something?
Yes, obviously. I think that it will be the final question and comments, taking into account our time. So I would like to ask like general question and want to involve also constitutional law scholars, because this is the issue that can connect those who are interested in human rights and also in the constitutional law. And I would like to ask about electoral campaign. What do you think will be the situation in Poland? Like if our politicians will involve this issue of abortion, because Donald Tusk said that Polish women should be entitled to abortion rights. Because this situation was also important during electoral campaign in the United States. So there is a prediction or belief that abortion issue will have this impact on the election results. And this is connected with also what has been said about young people and especially young women. So what is your opinion whether young women can change Poland, not only in the issue of abortion, but generally? Can they save us simply? So this is my general question for anybody who wants to engage in this discussion.
I would say that Magdalena has the floor first, and then we go around with all the others who raise their hand and wants to take part. So please, Magdalena.
Okay, I can see also the question from Karolina Ciemno-Czołowska on the chat, which actually is in line with Agnieszka's question. What is the most important change that needs to happen in people? I would just give a very prosaic answer. I just love to that women take into account their own interest in taking electoral decisions, and our vital interest is to have right to choose, even if we do not want to perform that right. And women shall just take that one criteria into account during the voting. And we shall, as women, be aware of that there is a huge difference between being for abortion or being for right to abortion in any cases. And I would say that being for the right for abortion or to abortion, it doesn't mean necessarily being for abortion in general. It's about women's subjectivity in general in law, and our full participation in public and also private life and enjoyment of our rights. And I would love to see the time when women during their electoral decision would take into account their own reproductive interests.
If I may add something, Agnieszka, when I start my classes with my students, I always start from the probably most famous sentence of Voltaire when we talk about rights. I don't have to agree with your position, but I will always fight in order that you will feel free to express your position. Probably with the younger generations, the problem that we have is that also our generation and the previous one have failed in teaching them how to think. So we observe an increasing amount of very opinionated young people who are strongly supporting the Schmittian dichotomy, friend-enemy. We should teach them to think and to respect even those who dissent. And this is true in my understanding with regard to reproductive rights, but also many other aspects. We are also observing a dramatic situation with regard to freedom of expression in our Europe. This is another point that we need to take into consideration. Rights from all the points of view are being curtailed. And maybe this is because we lost the ability to clearly and frankly speak about several topics and to understand that we, as Magdalena perfectly said, just give an option. It doesn't mean that we will need to take that option. This is the reason why in several circumstances I'm more afraid than hopeful when it comes to young generations, because I'm not sure that they will understand what does it mean giving a choice to the others. I'm sorry for this pessimistic contribution, but I think we need to be also realistic. Any other who wants to join us?
You, Valentina, because yes, with the young generation, it was also the question in Poland, yes, because we have those two judgments of Constitutional Tribunal, 1997 and 2020, and they were connected with both like protests supported by young people. And yes, 1997, and we have again the situation in 2020, again support coming from young people, and nothing has changed. Yes, so people just adjusted to the situation, which is unfortunate in my opinion.
I totally agree, of course. So maybe if we don't have any other comments, Agnieszka, I will give again the floor totally to you for closing comments or remarks. What do you think?
Yes, thank you. So yeah, thank you everybody who joined us today. Thank you, Valentina, for your moderating our meeting, and thank you, Magdalena, for your insights. This was the first meeting, but obviously not the last. Please expect another meetings. I will send invitations and provide some description for another topics. Today I would like to thank you for joining us again, and have a nice evening and weekend. So thank you very much.